Laura Farris.
Thank you very much, Dame Eleanor. It is actually genuinely a pleasure to follow the member for Edinburgh South West, and I'm going to try and avoid too much mince in my own speech, but continue in the respectful tone that she just struck. I'd like to take the heat a little bit out of this debate and say I think that the British people would recognise in the United Kingdom a country that has honoured its commitment since the launch of the 1951 Refugee Convention to offer sanctuary to those with a well-founded fear of persecution. And the record of the last 7 years, where close to 500,000 people have been granted asylum on humanitarian grounds, bears testimony to that. Now, I think they would also recognise that there are peculiar and unique problems that have arisen with the small boats crossings. 5 years ago, in 2018, 300 people made that journey. Last year, it was 45,000. Of those, 80% were men, aged between 18 and 40. All of them had paid a people smuggler. All of them had the physical strength and the wherewithal to make a journey across continental Europe and through the small boat. And we know that a third of them arriving last year were Albanian. And I just want to read what Dan O'Mahony told the Home Affairs Select Committee, I see the chair is in her place, when he appeared before you last October, and I'm quoting verbatim. He said about the Albanian arrivals, "The rise has been exponential, and we think that that is in the main due to the fact that Albanian criminal gangs have gained a foothold in the north of France and have been facilitating very large numbers of migrants. Whatever sort of criminality you can think of, there are Albanian gangs dominating in this country, be it drug smuggling, human trafficking, guns, prostitution. So a lot of the Albanian migrants are not actually interested in seeing their claim through. We will typically put them up in a hotel for a couple of days and then they disappear into the underworld." Now that unique and specific problem requires a unique and specific answer. I think we all agree on safe and legal routes. I won't improve on the remarks made by the member for East Worthing and Shoreham, but it was a powerful speech. And I think I heard from the front bench for the first time tonight, actually, that the Labour Party is also endorsing quotas, which is part of this bill, and we agree with that. If my intervention earlier wasn't clear enough, what I was simply saying is that Harvey Redgrave, writing for the Tony Blair Institute, in a really thoughtful piece actually last July, was talking about safe and legal routes, out of country rights of appeal, quotas, but he was also talking about an absolute prohibition on small boat arrivals. And that really is the issue in this legislation where we're having a dispute. Now, actually, Dame Eleanor, I rise to speak in response to new clauses 131 and 132, two Conservative clauses, and it's very unusual. Well, actually, they both then, one is in his place. It's very unusual for me to speak in response to... Yes, I will give way, sorry.
Just before the Honourable Lady moves on, and I'm grateful for her giving way, of course, what many countries do is have a cap per se on immigration. In Australia, Parliament debates an annual cap. When David Cameron and George Osborne were running the Conservative Party and the Honourable Member, the Right Honourable from Maidenhead was Home Secretary, we said that should be tens of thousands. Perhaps that's what we should go back to.
Well, I think it is certainly true that the promise which is inherent in the Refugee Convention, which is an offer to the world at large, which was conceived in an era pre-EasyJet, pre-people going on holiday to any country, pre-mass migration, certainly requires a different lens to look through it in the year 2023, and many of our international partners are now talking in this way, and we may have to have a debate on that in a different occasion where we talk about that issue more broadly. But responding to the... I'm just going to make a tiny bit of progress. I haven't really started and there's not that much time. I'm going to respond to new clauses 131 and 132, and together they do something slightly different, but they have the same effect. Dame Eleanor, I'll look at you, and I hope that my honourable friend for devisers won't be offended if he has to look at my back. But one of them excludes the jurisdiction of the European Court of Human Rights, and the second clause seeks to disapply the relevant sections of the Human Rights Act insofar as they may be relevant to decisions that are taken in this bill. And I want to say at the outset, I understand the impulse that has brought my honourable friend here, and that is the frustration with the exercise of the Rule 39 injunctive relief decision in July, which the Honourable Lady covered so well in her speech. But she will know as well as I do, and I think she even said this, Rule 39 is not an inherent part of the European Convention on Human Rights. She said in her speech it is a rule of the court. The decision was taken by a single judge alone. She's quite right to point out that that is common and standard in injunctive proceedings. But it is nonetheless true that it is somewhat surprising to see that matter go through the eyes of the High Court, the Court of Appeal here, finally the Supreme Court, and then be overturned by a decision of a single judge in Europe. And I simply just say this, we don't even know who that judge was, but we know that Tim Ike, who is our own British judge who sits on the European Court, has never even, I say this with absolute deference to his brilliance, and of course I'm not criticising him, but it is standard for the European Court of Human Rights, but he has never sat as a High Court judge, he's a barrister, and therefore it is odd to see our own Supreme Court, some of the most brilliant justices in the world, being overruled by somebody just as a court rule, who is probably not of their status, and I think that is a true statement.
For giving way, because I also went on to say this, that in the case of Palladia against Moldova, the Grand Chamber held that a failure to comply with interim measures amounts to a violation of Article 34 of the Convention, because the high contracting parties have undertaken not to hinder in any way the effective exercise of the right of applicants to bring their claims before the court. So, whereas it was originally in the rules of court, the Grand Chamber have now said that failure to obtemper that, to comply with that, would be a violation of Article 34 of the Convention.
And I take her point, and we are obviously adhering to that. But as a rule of the court, and if I can just perhaps move on a bit from this, I've been very glad to read recently, whether it was a press release or a tweet, I can't recall, but it was from the Home Secretary herself saying that she was very glad that constructive talks were now taking place between representatives of the British government and members of the European Court on Human Rights, focused on resolving that issue. I say that's good because it should actually, I think, be possible to resolve that issue, since it is a rule of the court rather than a principle of human rights, and I hope we can move on from there. But if I may say with great respect, I do not accept that that decision in itself justifies these amendments, and I think both of the two amendments are weak for both legal and constitutional reasons, and I'll set out why. First of all, my honourable friend, the member for Middlesbrough, Middlesbrough South and East Cleveland, said that he relied on a paper that had been written for Policy Exchange by Richard Eakins and Sir Stephen Law. I do challenge the expertise of both of those people. I question it, and they've both, or one of them certainly has contacted me in the past. Neither of them are actually practitioners, and I do think it shows in their writing that they're not regularly in court, and they seem to get... I will in a moment. I'm just going to make my points. So the first element of the amendment, which seeks to exclude the operation of the Human Rights Act, the only realistic basis which somebody arriving via small boat could challenge their removal to a safe third country under the Human Rights Act would either be relying on Article 2 or Article 3 of the European Convention. That is the right to life, or not to have one's life endangered, and the right to freedom from torture. However, it is important to note that that would not be the starting point for this kind of claim. The starting point in our domestic courts would be Article 33 of the Refugee Convention, the non-refoulement principle. It's not just there in the Refugee Convention, it's a principle at common law, it's a principle that is part of our customary international law. So even if you abolish the Human Rights Act insofar as it applied to these cases, you would still have the same argument being advanced that the person could not be sent to a country because of a fear of persecution. And indeed, I'll come to you in a moment, I'm sorry, but the authors actually, the member for Middlesbrough South, the member for Devizes, the member for Stoke-on-Trent wrote an article in Con Home today, and they said and endorsed, individuals will not be removed if they're medically unfit to fly or would face persecution in their destination country. That's the non-refoulement principle, which is absolutely at the heart of the Refugee Convention. And one of the things which shows, I think, that there isn't expertise in this is that the same principle ripples through the common law, the Refugee Convention, the European Convention on Human Rights, and it applies across the board. It's even set out in terms in this legislation. So, as I say, it would be pointless to derogate from the Human Rights Act on this, because the principle that protects people from persecution is so embedded in any event.
Is the Honourable Lady going to give way?
I will give way, sorry.
I just wanted to just point out to the Honourable Lady that Professor Eakins and Sir Stephen Laws respectively, just in case other members of the House don't know this. One is a professor of law at Oxford University, and the other one is former First Parliamentary Counsel. And I rather think that that's rather a good credential compared to some of the views of what I would describe as ordinary barristers.
Well, my point, no disrespect is intended, but it's just clear that they're not frequently in court arguing these cases, because if they were, they would know the way that the law ran. And I'm just going to go a little bit further in my speech. The second point is that, yes,
I know myself and the Honourable Lady don't agree about a lot of things, but I believe she does have an expertise in this area. That's correct, isn't it? As a barrister, the Honourable Lady has an expertise in this area and has practised in this area. So I think, perhaps I would suggest to her friends that her views deserve a degree of respect.
On this side of the House, the MP who's most recently been in the immigration tribunals, and so I have an idea of, but I'm not, it isn't my principal practice area, but I will just take one other point. The other thing that I think is relevant is that Parliament has in the past successfully recalibrated the interpretation of the Convention, changed the way it's interpreted, and have no difficulty with that. Now, we know that this bill already takes a number of novel steps which I think are necessary in relation to established law. First of all, it creates an absolute duty of removal on the Home Secretary, and that applies irrespective of any human rights claim, with the exception of the non-refoulement principle. It also expands powers of immigration detention, granting the Secretary of State a power to determine the period that is reasonably necessary, in some ways overriding established Hardiel Singh principles. And thirdly, it limits the rights of appeal. The individual has a right of appeal, but that's capped at 1. Now, in my very respectful submission, the government must have the opportunity to see these clauses enacted, because I believe that they will be upheld by the European Court of Human Rights. I think back to 2012, when the coalition government changed the immigration rules in relation to the issue of the deportation of foreign national offenders and the application of Article 8, which is the right to respect for private and family life. Parliament took the view that that was being interpreted too often in favour of the former criminal, ex-convict. And as a result, it set new rules in the established immigration rules at section 398 onwards, which made it clear that there were very limited circumstances in which Article 8 should be engaged. It made clear, Parliament said in terms, that the balance should be struck in favour of the overwhelming public interest in deportation above any Article 8 claim, unless there were very compelling circumstances to the contrary. That was upheld in successive decisions by our appeal courts, beginning with MF Nigeria in the Court of Appeal. Now, that decision by Parliament to basically circumscribe the ambit of Article 8 when it applied to criminals was taken to the European Court of Human Rights, and for years actually they wouldn't even hear the issue at all. But then in 2017 they did in the case of Ndidi, and I reminded myself about how they approached that case today. And in fact, the argument was being made, quite a compelling Article 8 argument. The person had arrived as a baby in the United Kingdom, they'd never been anywhere else. The offending was quite low level, it was sort of drug dealing rather than any harm to the person, and the courts here have obviously said that he must be deported to a country that he'd never been before. He challenged the European Court of Human Rights, and the European Court said no, the British government is absolutely entitled to circumscribe the application of Article 8 in the way that it has, and his claim was rejected. And so my simple point is that you can do things in the way the government is seeking to do in this bill, which may well be compatible with the European Convention of Human Rights. And I have really struggled to find any example of the court overturning primary legislation, which is what this is, or constructing it in a way that is disadvantageous to the member state. And I would just make one point. The fact that so many MPs go back to the prisoner voting case doesn't actually enhance their case. That case is 20 years old and has been reversed. I accept without reservation that that was wrongly decided. I think it was overreach. But I've heard nothing from these benches within the last 20 years that suggests that the court is still making the same mistakes. And I think the absence of any, again, we've talked about the Nationality and Borders Bill not being a success, but that wasn't because the European Court of Human Rights said it was, unlawful or overreached. We simply concluded that it didn't work. work yet. So for those reasons, I think the bill already goes very far, and I think it should be given the chance to work through, and I will give way.
Well, this is a fascinating description of the three ways you can deal with this. One way is to leave the convention altogether, which is what I would favour, and but that's not what we're proposing or debating tonight. The second way is to have some kind of notwithstanding clause of the kind that's been proposed. And the third way is to assume that through the interpretation of the court of the will of Parliament and Government, we will have our way. Now, the Honourable Lady is making a good case for the third, but the problem with that is placing a great deal of faith, although she says she does so on the basis of precedent, on the court to honour the will of this House. And I'm not sure that I would have the same degree of faith, and I recommend to her, as she doesn't like Professor Eakins and so on, to look at the Home Secretary, when she was Attorney General's speech on the interpretive matters she describes, which she gave to Cambridge University.
The Honourable Lady sits down when someone else is standing up. Laura Farris.
Sorry. Just to come back on that, I think it is dangerous to conflate what I think has been understood on these benches to have been court overreach in the application of Rule 39, with which I agree, with an over-enthusiasm of the court to involve itself in primary legislation, which is what this is going to be. And I see no precedent for that concern, so I hope I can allay your fear to some extent. And then the final point that I wanted to make is... Yes, I will, yes.
Very grateful to my honourable friend for giving way. Is there not a fourth option to add to the list of our right honourable friend from South Holland and the Deepins? Call me old-fashioned, if you will, but it's just to make sure that His Majesty's government ensures that we meet our international obligations wherever they are. That is option 4, and is one which I think commands quite strong support across this House.
Well, I thank my honourable friend for his intervention, and it brings me on to my final argument, that I think it is a dangerous path to go down, wrenching change from either the applicability of the Human Rights Act or from the jurisdiction of the court. The European Convention on Human Rights is fundamental to the devolution settlements in Wales and Northern Ireland, and it also plays a distinct role in the Belfast Agreement, the Good Friday Agreement. And I just wanted to read out, since we're so near to the 25th anniversary of that agreement, how the European Convention on Human Rights was framed as an integral safeguard, and I quote, "There will be safeguards to ensure that all sections of the community can participate and work together successfully in the operation of these institutions that all sections of the community are protected from, including the European Convention on Human Rights, which neither the Assembly nor any public body can infringe." So in a climate where at the time of the conclusion of that agreement there was a deep scepticism about British courts following, for example, the establishment of diplomat courts and other things which were controversial at the time, it isn't just something that is paid lip service to, but it's integral to the proper functioning of that agreement. I would add, and I must add, the proud history we have in the formation and construction of the European Convention of Human Rights. It's well known that David Maxwell Fyfe was a Conservative MP, and it is also for that reason, actually, it's unsurprising that we are one of the states with the lowest numbers of adverse findings. I think we should be very wary of quick fixes. We said throughout the Brexit debate we'd be taking back control of our borders, but it's more complex than that. And the point I'm making, actually, in this speech tonight is leaving the convention or derogating from the convention is not the answer. It won't do the job anyway, and I think it will. I think it will undermine the effect of this bill, which I think will be upheld as lawful by the European Court of Human Rights in the event that it's referred there.